Namaste. Greetings to everyone. I am Ridul Agarwal, an advocate and mediator at the Supreme Court of India and a part of Nivaaran. Today is the 8th day of 4th International Virtual Mediation Summer School presented by Nivaaran, the Mediators of Supreme Court of India, in collaboration with Singapore International Mediation Center and Commonwealth Lawyers Association. In the past 7 days, we have had extensive flow of knowledge by national and international mediators as guest faculty. The Summer School 2023 was declared open by our very own Mr. Justice K.V. Vishwanathan, Judge of Supreme Court of India, in the presence of President, Singapore International Mediation Center, Mr. George Lim, and President of Commonwealth Lawyers Association, Mr. Peter Menard. Justice K.V. Vishwanathan emphasized on ingraining the concept of mediation as culture in legal fraternity. Mediate, don't litigate, are the golden words of Justice D.Y. Chandrachud, the Chief Justice of India. For this, advocates at large have to develop a general tendency to resolve disputes in their chambers. Mr. Brian Spears, former President of Commonwealth Lawyers Association, while delivering first lecture for the Summer School 2023 on historical perspective of mediation, mentioned about peace jurisprudence. To value problem-solving lawyers, he underlined the words spoken by Abraham Lincoln that lawyers should be equipped with negotiation skills. On the second day, Mr. John Bessie, President Jamaica Bar Association, throws light on conflict management, resolution, and transformation. On day 3, Deputy Attorney General and Deputy Minister of Justice of Ghana, Madam Diana Swanba, elaborated mediation with the focus on lacuna and disadvantages of adversarial dispute resolution. On day 4, Professor Andrew Goodman, barrister at London, explained communication where he said, silence is the best form of communication for a mediator. On the 5th day, Madam Sushila Sarathi, Senior Advocate, Karnataka High Court, explained negotiation skills for a mediator as a facilitator. She emphasized on the phrases such as what I want and why I want what I want for the parties to understand. On the 6th day, we had Madam Uma Ramanathan for Madras High Court, where she spoke on ethics with major components being confidentiality, neutrality, and self-determination. We look up to Madam Umanathan and Madam Sushila Sarathi for being the pioneers and teachers of mediation to our fraternity. Yesterday, that is day 7, Justice Sudhir Jain compared online and physical mediation. The world has become one because of the advancement of technology. While we would any day prefer physical mediation as it has its own merits, online mediation has certainly made us reach further and has made us assist parties more. With this, we have come to today's session where I am privileged host. I welcome all the participants, senior advocates, and judges for today's session on the topic mediation advocacy. Today's topic is based on the Vedic era culture, Sarve Bhavantu Sukhina, Sarve Santu Niramaya, meaning thereby, let everyone be happy and healthy. Let the culture of mediation spread all over so that we, the lawyers, start understanding the expectations of other party as well. We have amongst us our esteemed speaker, Mr. Duncan Turner, who will be enlightening us on today's topic, mediation advocacy. Mr. Duncan is a practicing advocate with a diverse commercial practice in which most matters involve technical and complex disputes on transaction. He spent a year working as a foreign lawyer, that is in 2000 to 2001, at Inse and Co. Solicitors in London, and was a partner at Webner Wenzel, a large South African firm, before his call to the bar in 2005. Duncan advises clients on corporate transactions and in dispute resolution involving mainly following industries like energy, insurance, construction and engineering, telecoms, banking, and financial services. He has appeared in the South African High Court, appeal courts, competition tribunal, competition appeal courts, as well as in arbitrations and mediations and various administrative bodies dealing with both domestic and international disputes. He is regularly appointed as arbitrator in both ad hoc and AFSA administered arbitrations. Duncan is also regularly appointed as mediator in commercial disputes involving a broad subject range, including commercial and industrial supply agreements, construction and engineering disputes, shareholders disputes, leases, funding agreements, personal injury claims, insurance contracts, and binder agreements. In his role as chair of the AFSA Mediation Division, Duncan is involved in the training of mediators and in marketing to potential users of mediation services. His current focus is to bridge the perception gap between mediation practitioners and potential users of mediation services in South Africa and the broader Southern African region, so that mediation is considered and used by dispute resolution practitioners and their clients at every stage of the dispute process. He encourages flexibility in the use of mediation at different stages of litigation and arbitration. Sir has also been recommended for conferral of Senior Counsel in 2021 and is chairman of Mediation Division in Arbitration Foundation of Southern Africa, that is AFSA. Turner is an accredited mediator by CEDAR, and furthermore, he is also an AFSA arbitrator with fellow of the Singapore Institute of Arbitrators. As another feather in his hat, he is also an acting judge in Johannesburg High Court ad hoc. We welcome you, sir. After the lecture, we will have interaction session. Please post your queries in the chat box. Over to you, Mr. Duncan.
Riddle, thank you very much. I hope everyone can hear me. That was when one hears things like that spoken about someone, you wonder who they're talking about. But it is a great privilege to sit here in a winter's day in Johannesburg and to address a very distinguished group. And I'd like to acknowledge the distinguished guests on the panel, the Nivaaran faculty, the Singapore International Mediation Center, and all of my friends in India sitting and at lunchtime on a Sunday to listen to me. I want to say a special thank you to Santhan for inviting me. I knew that Santhan and I shared a passion for cricket, which we have discussed over many years. But it is a great delight to know that we also share a great passion and belief in mediation as a method of dispute resolution. In the opening ceremony, there was mention of Mahatma Gandhi, of Nelson Mandela, and I have the privilege of living in the country where both of them formed their views of their world. Gandhi spent the first 20 years of his career in South Africa learning about mediation. The story goes that the first court case in which he was involved, he persuaded the parties to arbitrate and then to settle on an amicable basis. Nelson Mandela will be known to all of you too. And he too was a lawyer who recognized the importance of talking rather than fighting. My topic today is mediation advocacy. And to the casual observer, there may be an ambiguity in that term. Should I, as a speaker, address advocacy for mediation and discuss the different ways in which mediation may be promoted? Or should I, as a speaker, address advocacy in mediation, focusing on the skills of a party's representative involved in the mediation? Now, both are legitimate and important topics. And I would suggest to you that the relevant perspective is that of the representative, the party's representative in mediation. And the party's representative in mediation should be both an advocate for mediation and an advocate in mediation. And the principles that we talk about here are principles that are relevant both to the lawyers who represent parties, but also to non-lawyers, whether they be in-house representatives or parties who are engaged to assist the party in mediation. So I'm going to focus on a lawyer because I understand that the majority of the participants here are trained lawyers. And so the perspective from which the listener will be coming is that of a lawyer. So what is the role of a lawyer? The role of the lawyer is to advise, but the role of the advocate is ordinarily to fight. When a dispute arises, the party will appoint a lawyer. And the stereotype expects, just like in the legends of old or American TV shows, the lawyer will swoop in, take the role of the hero, and save the day. That's what the public expects of the lawyer, and unfortunately, that's what most lawyers expect their role to be. And when the dispute arises, the lawyer is appointed to assist the client in the dispute, and his training and instincts will immediately respond to assess the information and work out the best method to protect and improve the client's position. Automatically, the lawyer's instinct is to focus on positions and not interests. This is the script of the traditional dispute resolution process, where the details of the dispute are handed to the lawyer and the lawyer takes control of all matters. And it is ordinarily understood that the lawyer is the person that will take the matter to the conclusion. And I ask you rhetorically, is this true of mediation? Unfortunately, in mediation where lawyers become involved, the lawyers often assume that this hero role is required. Consequently, when the mediation starts and the lawyer is engaged, the lawyer will continue to perform the role of that hero or advocate in a court, both prior to and during the mediation. But hopefully now, on day 8 of this course, the listeners will know that mediation is different. In mediation, the lawyer is not the person who gets the matter to its conclusion. Mediation is a client-driven process. In mediation, the client must be empowered, and the client must be allowed to be the hero. So what can the lawyer do? My experience is that when mediations are unsuccessful, an unsuccessful mediation is because the parties were not prepared for the mediation. There was inadequate preparation, but inadequate preparation is different from for a mediation is different from inadequate preparation for a court hearing. A lawyer who is prepared as he would for a court hearing is not necessarily prepared for a mediation. Because when a lawyer prepares for court, they're preparing to understand positions, to understand rights, to understand legal arguments, and they are ready to put their client's best position forward. And they may be ready to anticipate and respond to the best position from the other side, or the best arguments from the other side. But that's not the role of a lawyer in mediation. In mediation, you need to be prepared for a mediation, not prepared for a court case. So if you have listened to the lectures this week, you would have heard that a mediator is required to develop a set of skills and to focus on key principles. You would have heard phrases like focus on positions, not interests. You would have heard phrases like, consider all the relevant information, consider all of the relevant interests, consider all of the relevant options. You would have heard people say, assess the best alternative to a negotiated agreement, the BATNA, or the worst alternative, the WATNA. And you would have heard everybody saying, maintain flexibility and think creatively. Now, each of those terms and each of those skills that the mediator is encouraged to have are skills that the advocate needs to have and will understand and to have. Because if the client is going to be empowered in the mediation process, and the client is going to have the confidence to resolve the dispute, the advocate, the best advocate in mediation, is the advocate who places their client in the best position to have that confidence. And so I would suggest to you that there are 3 stages at which you can play a role as an advocate and be a positive force in a mediation. The first is to be part of the conversation when deciding when to take a dispute to mediation, because that is an important stage. If you take a matter to mediation at the wrong stage, your chances of success are limited. The second is when you are involved in the preparation for the mediation hearing. So when you've decided we are mediating, we are going to a mediation, how do we prepare? And the third stage at which you become a resource and a good mediation advocate is in the mediation hearing itself. Now, we've got limited time today, and you will have heard what the mediator will be trying to do. And so your role in the mediation, as a mediation advocate in the mediation, we will touch on. But I want to focus on the first stage and maybe a little bit into the second stage. But when should we be taking a matter to mediation? Now, when I ask that question, there may be a number of people in the audience who tell me that this is prescribed. The court rules will tell us, or the rules of an arbitration institution will tell us. But I think the analysis needs to be a little more carefully done. Because the success or failure of a mediation will depend on whether or not sufficient information is available to the parties and to the mediator to find options, explore them, and resolve on an acceptable solution. And if we don't have sufficient information, the opportunity to settle is significantly limited. So it's that flexibility that I want you to just keep in mind as we talk through when the best time to take a matter to mediation is. And just to kick that off, I'm going to use 2 examples. The first example involves a car accident. Imagine a motor car accident where, and I'm going to use Santhan as my co-conspirator. Santhan and I are driving our motor cars along. He owns his motor car. I own my motor car. And we have a collision. We both appoint lawyers to assist us in the dispute. Now, I ask the question rhetorically, when will we be in a position to mediate our dispute over liability for damages in that collision? And I suggest to you a type of dispute like this would be resolved almost immediately. As soon as he has a quotation for the damage on his car, and I have a quotation for the damage on my car, we can take that to mediation. Pre-litigation mediation in that situation is a very good idea. But why? The reason is I have authority to decide what happened, what I can and can't do with my property, my motor car. I am the beneficiary of any payment that will be made, or I am liable to make any payment to Santhan. Similarly, I was there. I know what happened. Santhan was there. He knows what happened. He has sufficient information, and I have sufficient information to engage in a mediation with the authority and resolve the dispute. Let me posit a different example, one that occurs in South Africa, and I'm sure it happens in India too. Let's posit an example of a man who unfortunately dies in the care of a public hospital. So the patient is in hospital and he passes away. The circumstances appears to be something incorrect with the circumstances, and the man's widow now wants to sue the hospital. The hospital would be represented by an administrator. In South Africa, it would be the hospital administrator or the government official in charge of public health. Now, if there is going to be a resolution through a mediation, the resolution needs to be authorized by that public representative. That bureaucrat is the person that is going to have to make a decision over whether or not that matter can be settled. I ask you now, can we go to pre-litigation mediation? Could we go immediately to settle that matter? Now, the fundamentalist in mediation may say, of course you can settle anything at any time. But the realistic lawyer and the realistic dispute resolution practitioner will know that the widow is unable to take a decision. The widow doesn't know what happened. She wasn't in the hospital. Until her lawyer or the doctor who is assisting her is able to get access to the hospital records to see what happened, she has no insight. There's even a greater complication in the office of the hospital administrator, the bureaucrat, because not only was the bureaucrat not at the bedside, but the bureaucrat will have to answer for whatever decision he or she makes. Now, if you are the mediation advocate for the hospital administrator, what is your role? You've been briefed by the government to defend the public hospital, and the person who gives you your instructions is the hospital administrator, the bureaucrat. How can you take that person to a mediation and ask them to settle the case? What can you do? And those are the kinds of questions that the legally trained advocate will ordinarily not even ask. Those are questions that the legal advocate won't ask. They will just say, well, my brief is to defend the hospital. I will find the best legal answer to the legal problem that's being presented, and we will argue our case. And I want to challenge you to say that when you find yourself in that position, that you consider your legal options, your court options, but at the same time, consider the benefits of a mediated outcome and when that mediation should take place. And I'd suggest to you that the relevant factors to take into account are, number one, the empowerment and authority of the client's representative. Number two, your side's understanding of the risks. Number three, the costs of the various alternative options. And those three factors will ordinarily be involved in whatever case you find yourself in. Different cases will have different factors that play a role as well. But I want to focus on those three, because if those three are adequately addressed, we find ourselves with far more flexibility and a far greater likelihood of successfully achieving a mediated outcome. So if I were to take you then through this question of what is your role as a mediator, as a mediation advocate in that first stage, and to look at how information becomes available and how costs will build up, I'd suggest that one can look at a curve, and I apologize, I don't have the proficiency to put a graph on the table, so I'm going to appeal to your imaginations. But if you can imagine that every case has an information curve or an information graph, and every case will have a cost curve or a cost graph. If the horizontal axis is time, you will get more information over time, and you will spend more money, incur more cost over time. But different cases will have different curves. In my example of Santhan and I in a motor vehicle accident, our information curve starts very high up the y-axis, up the vertical axis. We have lots of information right at the beginning of the process. If we were to go through a litigation process, we would get slightly more as we understood, we perhaps got document discovery in the process, and we might learn slightly more at the trial. But there is far more is known early than you learn later. The cost curve in that example will run up as time goes by. The more time you spend with lawyers, the higher the cost. When you have document discovery, the cost will go up. As you prepare for trial, the cost will go up. As you go through a trial, the cost will go up. So when you compare the benefit, if you sit at the beginning, and the speaker earlier in the week spoke about doing an exercise on the back of an envelope. If you do this exercise on the back of an envelope at the beginning of the hearing, you know when you're going to be spending money in a trial, in a case, and you know when you're going to be getting the majority of the information in your case. And so, as a responsible lawyer, you can advise your client on when the most likely point in the case will be, when you will have sufficient information without having spent too much cost and time. I go back to the hospital example. At the hospital example, your information curve starts right down on the zero at the beginning, at the axis, because you have no information. As you go through a discovery process, document exchange process, you'll get more information. It may be that you don't have enough information then. You may need to go and see an expert. You may need a doctor to advise you, on what the information means. Once that person has given you that advice, you may then have enough information. But you will plan your litigation you will plan your mediation to place your client in the best position, not whether they're going to win or lose. That's how lawyers think. You will place them in the position where they have adequate information to make an informed decision. So that is the framework in which I would suggest to you that the relevant investigation and the relevant inquiry needs to be made. Now, going back to the bureaucrat or the public official, and with the greatest of respect to them, I'm sure that bureaucrats in India are very similar to bureaucrats in South Africa in many respects. And one of those respects will be the importance of being able to explain any decision they made. If they are responsible for the decision that was made, there will be someone in that bureaucracy who will hold them accountable for that decision. Now, if that person is unable to justify the decision, it's their inability to justify the decision that will get them into trouble, not the decision itself. And unfortunately, and we've seen it in our country, and I'm sure you've seen it in your country, there will be people who would rather make no decision and allow the court to make the decision for them, even if that decision leads to a much higher liability for the hospital or the government, than to take a decision at an early stage for a lesser amount if they are unable to explain that decision when they are asked. So if you are in a position as a mediation advocate, advising a client, particularly a client in government or a client in a corporate where the person giving the instructions is a functionary, that person needs to be able to explain the decision internally. They may have the authority to take that decision, but they need to have the confidence to make that decision. And that confidence is something that you, as a mediation advocate, should be able to bring to your client. And that confidence lies in the ability, objectively, to assess the information, assess the interests, understand the position that has been taken by the other side, understand the interests that exists on the other side, and to provide a framework within which the decision can be explained on a rational, objective, justifiable basis. Now, as lawyers, that seems like common sense. We'd like to think that that's how all our decisions are taken and how all our decisions are made. But I think on reflection, we know that that's not true. Decisions are often made in different ways, and very often decisions that are taken by clients are not rational decisions. And so I would suggest to you that at the beginning of this process, where you have the ability to influence when the mediation should take place, that you give your client the very best chance to decide on the very best chance to feel confident when they go into that mediation, that they will be in a position to make the right decision. So that's the position in relation to the first stage. I'm going to deal briefly with the preparation for the mediation. As a mediation advocate, I would suggest to you that your focus needs to change. When you prepare as a litigation advocate, you are preparing to win. You are preparing to get the best outcome in court, which is a win. Because in court, people win and people lose. When you prepare for mediation, your focus is different. When you prepare for mediation, you want the mediation to succeed. And so if you prepare for mediation with an eye on making the mediation successful, you will then place your client in a position, in the best position, to achieve a successful outcome in the mediation. Now, that may sound a little cryptic, but it's not cryptic if you remember that the client has full control over whether a matter settles in mediation or not. Control in a court is given to the court. Control in mediation is retained by the client. And so you must have confidence that at the end of the mediation, if the client agrees to terms that settle the matter, then the mediation has been successful, even if you, the lawyer, don't like the terms. You, the lawyer, may think your client could do better. But that is where you have to recognize your role. You are not the hero in the story. The client is the hero in the story. And the client needs to be satisfied that his or her interests are protected and are best served by a mediated settlement. And the way you assist in that process is giving the mediation the best chance of success. And so when we talk to mediation advocates, when we talk to lawyers who are there to assist their clients in mediation, it's to remind them to place mediation, a successful mediation, at the pinnacle of success, and not success for the client in mediation. I'd like to just let that drop because it's if you just want your client to succeed and your client to get what it wants, and both sides have equally able lawyers, you're not going to get very far. But if you have lawyers who recognize the interests of their clients, recognize that there are competing interests, but both are focused on getting the mediation to be successful, you have much greater potential for a successful resolution in mediation. So when you prepare your matter for mediation, I would encourage you to look at the types of issues that you expect the mediator to be interested in. Consider the types of information that the mediator will be looking to extract from the parties. What are the kinds of questions that the mediator is likely to ask? Now, you've had 7 days now of instruction on the types of things a mediator would be looking to do, on the types of things that a mediator is looking to achieve. So you have very good instructions of the kinds of things you will be looking to obtain from your client in the process of building up to the mediation. Because you will give your client the opportunity to think about the client's interests. You will be giving your client the opportunity to think about what the other side might be prioritizing. You will give your client an opportunity to assess risk options, not for purposes of responding to the other side, but for purposes of being empowered in the mediation to help the mediator find a result. Because it's the mediator who will be the party driving that mediation to a successful mediation. And so your role in this process is to assist the mediator to do the very best job he or she can do. I don't want to overstay my time, and there may be questions. These topics can be very controversial because it challenges the way people think about things. But if I could leave you just with a couple of headlines. The first is this: remember, as an attorney or as a lawyer, that a successful litigation or a successful lawyer's practice is not a single client with single matter practice. A successful lawyer's practice develops on return customers and happy clients who spread your reputation. So maximizing a fee out of a single matter is a very short-term view on a long-term career. Your long-term career benefits from clients who recognize your skills and will return. The second thing that I want to remind you is that you want to maintain trust at all times. Your client must trust you and must trust your advice. Your client trusts you in the litigation process and must trust you in the mediation process. If you are able to tell your client what is coming, what they can anticipate, what the mediator will be looking for in that process, and then you go to the mediation and your predictions come true, your client will recognize that you know what you're talking about. And you are never going to give up your client's interests. You are always going to give your client the true legal advice, but you will do so being part of the solution, not in order to put up obstacles and be part of the problem. And then lastly, that's the trust in the lawyer. But lastly, your last obligation in this process is to make sure that your client maintains trust in the mediation process. If your client is going to get to the end of the litigation process, they need to remain there and they need to trust that the mediation process is one that will work and will deliver a benefit. If you as a lawyer undermine the process, either by undermining the mediator or undermining the way in which the mediation is being conducted, second guessing things that are happening, you are undermining the mediation process. You are creating or reducing the trust that your client needs to have in the mediation process in order for it to be successful. So always remember that your role, if your client trusts you, they trust the way you react to the mediation process. And if they are to trust the mediation process, you need to maintain your confidence in the process and not undermine it. So I think I've hit my time. I hope I haven't overstayed my welcome. But I think that the role of the mediation advocate or the legal representative in the mediation process is something that people don't spend enough time thinking about and focusing on. I would encourage each of you, because we all act for clients, each of you to just keep that in mind when you are considering mediation and as your client approaches or engages in a mediation. Because if you as the lawyer can be part of the solution, you will add massive value to your client and to the mediation process. If you as the lawyer insist on rights and positions and arguing the case, you become part of the problem, not part of the solution. So good luck, and stand back and allow your client to be the hero. Thank you very much.
Thank you, Mr. Turner. It was really an amazing session that we have learned the practical jurisprudence of what we should do while in the mediation. And I think this is the lesson that we can never learn from any of the books, and nobody can teach us, and the practical solutions that you have given. So now we have certain questions that I would read out for you to answer. This is a question from Nilanili Srivastav. Sir, is it advisable to have a mediation process in the criminal justice system?
We in South Africa do have mediation in the criminal justice system. It can take place at different stages. The place where it works the best and is the most effective is in the parole system. So where a person has been convicted and they're now eligible for parole, in South Africa, the victim has a role to play in whether or not the convicted person should get parole. So the authorities are involved, but the victim is also consulted. And mediation can be a very powerful tool in resolving the animosity and difficulties in allowing someone to be released on parole. When one is dealing with the point prior to conviction, I think, I'm not a criminal lawyer, so I know that they have tried, but not in relation to serious crimes. So I think it's something that is discussed. I haven't seen it work in a pre-conviction set scenario.
Okay, thank you, sir. Now another question by same Mrinalini Srivastav. In case of corporate personality where the settlement has to be reached by a person acting for that corporation, can indulge in corrupt practice and gain at the cost of interest of that corporation?
That's a very insightful question. It is one of the most difficult things that a mediator has to deal with from an ethical point of view. Because of the confidence with which a mediator is required to deal with a matter, in our law and the way in which we teach it, we say that a mediator should recuse themselves from participating in a deal that appears to involve corruption. Because what we can never do is allow mediation to be a cover for corruption. And so the role of a mediator can be critical where corporate personalities are involved and where true and honest disputes are to be resolved. But if the process of mediation is used as a cover for corrupt practices, the mediator, in my view, should recuse themselves and not be prepared to participate.
Okay, yes. Thank you. So another question by Ms. Swapnil Goswami. Sir, in mediation advocacy, does the said mediation advocate of the client is solely duty bound and responsible to find and analyze the suitable BATNA and to put forth it on the table while negotiating during the mediation?
I think the short answer is no.
Yes.
But the long answer is that there's a very good example of what I described as the hero. In that question, it anticipates the lawyer coming up with an answer and presenting the answer as being the main protagonist in the mediation. I would suggest to the advocate asking the question that the role of the advocate is to allow the client, or make sure that the client has the information that will allow the client to explore the BATNA. So it's being advisor and assist and helper in providing the client, with the client finding the client's BATNA in mediation. That's the way in which I'd suggest you think about the process you're describing there.
Yes. Thank you so much. Mr. Santhanan, I don't think there's any more questions to go. Lawyers are...
There is one question by Kishore Dere.
Yes. Can BATNA of a particular case be significantly altered?
It certainly can, because and particularly from a lawyer's perspective, very often what the lawyer considers the BATNA is not the client's BATNA. And I'll give you an example. I had a matter with a cross-border trade where The claimant was an agent who'd had parts, industrial parts manufactured offshore. And the defendant had cancelled the order. Now the agent was in a position where his supplier factory had half-made parts. So they were not complete, but they had bought materials and they were sitting in the warehouse, incomplete when it was cancelled. The agent was under pressure from the factory to pay for the materials and the unfinished parts. The defendant was sitting, refusing to pay anything because they hadn't received anything. They said, I didn't get anything, so I don't want to pay. Now, the instructions from the agent's lawyer were that they couldn't get the factory to finish the items, that this was, that it was all lost, and this money now, these millions of dollars now needed to be paid, in damages. And they departed from that premise. So the plaintiff's lawyers would, in that situation, say, well, the best alternative is a litigated solution. We don't negotiate, I need to go and claim the money. Through the mediation, the factory representative was invited to come, and all of a sudden, there was a potential to complete the unfinished parts. So the lawyer's BATNA was a litigated solution. As soon as more information was available, a new BATNA arrived, which was that the factory could finish many of the parts that were sitting unfinished. And if they finished them, the defendant could buy them. So can the BATNA change? Absolutely. It just depends on the information and whether the right questions have been asked.
Right. That's true. Thank you, sir. There's one more question by Mr. Wasiuddin Dadini. Sir, lawyers are gatekeepers to a successful mediation. According to you, what should be the do's and don'ts for lawyers?
Yes, you are right. They are gatekeepers. And the reason they're gatekeepers is that their clients trust their advice. That's the reason they're the gatekeepers. And so I think your do's and don'ts is to use that trust to encourage a mediation, and you use that trust by showing the client the benefits of that mediation. In other words, do the work that the mediator would do the preparatory work that would allow the mediator to get the very best result in a mediation.
Mm-hmm. Yes, sir. So thank you. So in continuation with the earlier question, Mr. Sri Krishna is asking about that you said that the mediator should recuse himself. He said, so would the recusal of mediator from a corrupt party's mediation compromise the confidentiality of mediation itself? How can this conundrum be addressed?
Yes. These are always tricky, and they are fact specific. In South Africa, we have laws that would oblige a mediator to disclose something. So we have a statutory obligation on somebody who becomes aware of the existence of corruption, particularly significant corruption. There's a threshold level. But I would suggest to you that the mediator could do it two ways. You could do it openly to the parties and privately to the world, or you could do it privately to the parties and privately to the world. People may guess why you did it, but you can recuse yourself and still not compromise the integrity or the confidentiality of the process. But certainly from my perspective, and I may have a different the law in South Africa may be different. But from my perspective, if you participate in facilitating a corrupt result, you are party to the corrupt activity. And you don't want to, in the name of mediation, you don't want to do that and be party to it.
Exactly, that's true. Another question by Mr. Adinar Jones. How would make a case for co-mediators from an ethical and case-sensitive point of view, each advocating for the different parties?
Yes. Now, there are different models that have been tried. But I think, I don't think one can advocate as a mediator. But one can certainly have co-mediators who are appointed to engage more directly with each party or to engage more directly on particular issues. And I'll give you an example. I have been involved in a matter which has a big family dispute, but the dispute is really around business. It's the family business. So you've got different children, the grown-up children, inherited this business. You've got 4 children, 3 boys and a girl, inherited the business from the parent. The business is a very successful business. It's farming and agriculture, and they've fallen into terrible disputes. Their 2 children are on one side and the other 2 children on the other side, and it's causing massive damage to the companies. Their children don't speak to each other. It's a horrible, horrible fight. There, we suggested that we have a commercial mediator to deal with the business, etc., and to have a psychologist family mediator to do it together. And so they are engaging with the different disputes and issues collaboratively, where they can speak together. The commercial lawyer can explain the company structures and the ways in which the company solutions may be found. And the psychologist can debate and discuss the way in which the family disputes might be resolved. And so through that process, and a simple example, the half of the family that have been excluded, one of their real, the deep complaint, they never articulated it. But in the process, we found out that they were upset that their children, who are now 10 and 12 years old, have never been to the farm. So they wanted their children to experience this beautiful farm that the grandparents had, and they've been excluded. Now, the commercial lawyer wouldn't have found that out, but the psychologist did. And through that process, the family and the children now can go and have lunch next to the river on the farm with their cousins, rebuilding the personal relationship, which then allows the corporate relationships to sort themselves out. So there's an example of co-mediation and how you can get different skills to solve a problem.
That's a great example. So it's really great to have this kind of relations after this. One more question.
One from Jyoti.
Yes, sir. Let me read Mr. Kishore Dede. This is a new question that he's asking. Yes.
Please, go ahead.
In Singapore Convention, Dr. Kishore Dede is asking, is Singapore Convention having any favorable impact on minds of skeptical users of mediation?
I must confess, not yet. Because the Singapore Convention is still very new. And the majority of our mediations are domestic mediations. The Singapore Convention is an international instrument. Unfortunately, South Africa is not signed up yet. That is one of the things on my agenda, is to get it signed up. Mr. Lim will be happy to hear. But the Singapore Convention, I think, is something that adds gravity to mediation in the international sphere. And hopefully that will filter down to domestic litigation. But in my experience, our focus as in our domestic environment is to really get people to understand the benefits for themselves. And the Singapore Convention is a little bit above and beyond how mediation operates on a domestic level.
Yeah, thank you. This is Jyoti is asking, how can communication and understanding be improved between parties? What is the role of an advocate?
Yes, it's a tricky one, because if you are litigating and then you go to mediation, you want to keep that persona of the advocate, of the litigator. But I think the role of the advocate is to, and as I said in my address, the role of the advocate to improve communication is to allow the client to do the communication. Empower the client to communicate. Don't retain the communication amongst the lawyers. And because that, it may be in building up, you keep a cordial preparation for the mediation. But when there is communication with the mediator, both in preparation and at the mediation, allow your client to do the talking. Allow your client to feel empowered to make the decisions. That's how you improve communication, I would suggest.
Yes, actually, that is a very difficult aspect. That is the main, I think, difficulty that we face, making the two parties understanding. So this is one question more. Sir, this is Rakhi Buddhiraja. She is asking, sir, in your opinion, whether mediation should be applicable to criminal cases? If yes.
Sorry, could you just start that again? I lost you there.
In your opinion, whether mediation should be applicable to criminal cases? If yes, could it not be a tool in the hands of criminal to commit crime further?
Yes. Like I say, I'm not a criminal lawyer. So yes. My opinions have very little experience. But I can understand that concern, is that where you have the state as prosecutor on one side, the state is obliged to enforce the laws and maintain justice. You may undermine justice if you are constantly allowing criminals to negotiate their way out. So I think that's something that's a matter of policy, that the prosecuting authorities and the government would have to decide as whether, as a matter of policy, these are the kinds of things that should engage mediators, or which crimes might involve mediators. But I think that's a policy decision that is a difficult one to discuss from sitting in Johannesburg.
Okay. Yes, Mr. N.K. Rajput, are there any rules of evidence to be adhered to in mediation process?
No. The mediation process, and I think it's a very useful question because it's a lawyer's question. With the greatest of respect for the person asking the question. It's a lawyer's question because the lawyer is looking to understand the rules of engagement and to make sure that those rules are followed. Whereas in mediation, those rules disappear. And the flexibility of process, which includes questions of evidence and questions of who communicates, when they communicate, what they communicate, all of that is very flexible. And it's the flexibility that gives mediation its power. The only rules that apply in mediation are those relating to confidentiality and privilege, the without prejudice nature of the engagements. But as to what is discussed and how it's discussed, there should be flexibility.
Yes, that's true. Thank you so much. Now there's a couple of more questions. One is by Mr. Dhruv Teja. How to handle power imbalance between the two parties?
Yes. So I think this is where the mediator's role is the most important. So as a mediation advocate, you should be alive to the power imbalance. And I would suggest to you that if you are alive to it and you have the right priority, which is a successful mediation, you will manage your client and the process in a way that the power imbalance doesn't become an obstacle to successful mediation. But your client will know what power he or she has, and they will exercise it. And you don't want to lose your client's trust by undermining your client's feeling of power. So when it comes to the power imbalance, I think you need to be alive to it. Try not to allow it to be an obstacle, but then let the mediator manage the power imbalance. If you manage it, you try and manage it, you may undermine your client's trust in you.
That's true, sir. That's very correct. Yes. So the other question is, this is just an observation by Mr. Chinecharam. From my experience as a mediator, I have always believed that timing is very crucial in mediation if settlement will be achieved. It is great hearing that view echoed by our guest faculty today. Thank you, Mr. Turner.
Thank you very much.
Yes.
Thank you.
There's a little more questions.
Yes, sure.
Sir, this is by Mr. N.K. Rajput. Sir, can you briefly inform on the limitations of mediation?
The limitations of mediation really are the fact that you need agreement between the parties, that you can't enforce the solution. And if that is seen as a limitation, well, then it's a limitation. But it is also one of its greatest strengths. So the benefit of mediation, I think, will be viewed as a limit or a limitation by others. But it really is a process that allows the parties to retain control, where and that can be a limitation because you may not achieve settlement. But I don't think there's any limit on its effectiveness if it's properly employed.
Yes, sir. Yes. Thank you for the answer. And I think this would be the last question.
See, we have a participant in Jamaica.
Yes, in Jamaica. Yes, sir. Junior Campbell. In Jamaica, we have mediation in the criminal court, lower resident magistrate court, since 2021. It is applicable under the Offences Against the Person Act. Offences such as assault, OB harm, unlawful wounding.
Yes.
That's information, yes.
Yeah, that's a very useful insight. Thank you very much for that, because that's precisely the consequence of policy. So yes. It appears that in Jamaica, there's been a policy decision that in respect of certain crimes, mediation, and it's crimes against people. So you've got a victim, a direct victim, and a perpetrator, and that you will often find that they live in the same community. And so mediation has obviously been identified as a matter of policy as being something that is a useful element in the criminal process. So again, it's government's decision and government's policy as to what should be included for that purpose.
Yes, yes. Thank you so much, sir, for the answers. And in nutshell, that Mr. Turner wanted to communicate with us was that in nutshell, advocacy is partnering of advocates with the mediator to achieve resolution, redressal, and in our language, Nivaaran, of the conflicts resulting in the disputes among parties. And one more thing that Mr. Turner has touched upon, that our Justice K.V. Viswanathan has said about the government being the biggest litigant, and how to bring the government bureaucrats onto the mediation table has also been touched by our esteemed speaker today, and judge was also concerned about that. And the most important and the very important thing that Mr. Turner said is that what is the righteous time for the mediation between the parties to bring onto the mediation table? Because it's not always that he has given a couple of examples also, that it's not always that the pre-litigation mediation will serve in all the matters. So that is very insightful for us to understand. So, and it's a very interesting perspective on mediation. And one more thing that Mr. Turner said is that short-term view to a long-term career was a underlying line that we will carry home today, is in the mediation advocacy, is very important. Trust of your client is the biggest asset that you have in everywhere in the whether it's a mediation advocacy or otherwise as an advocate. Also the trust of in the society as such is also very important for any person to carry on, and the client's trust in mediation process is something very important that we have also seen over the years, and which you have pointed out, our esteemed speaker. The trust of the parties in mediation is very important. They have seen the litigation and they want to go run to this, like, putting them back to the table and making them understand what is mediation. You can get more, and it's a win-win situation. So many things that we have to tell them, but their trust in mediation is very important. So thank you so much from the core of our hearts. We want to say that it was a very practical knowledge that we have incurred today. And thank you so much from the Nivaaran team. Thanks a lot.
Mridul, thank you to you and to Santhan, to everybody else. I really appreciate it. Thank you.
Thank you. Thank you, sir. Thank you so much.
Absolutely outstanding and wonderful.